carrying it, but there is a public iPad.
All right, good morning. We're here on the self-represented family law docket for February 1st. I'm Commissioner Dave Nelson. All right, last time we were here, Ms. Gilbert had filed with this court a declaration by, I believe, Mr. Gilbert's current wife that raised issues about domestic violence being incurred or
Hey, why can't I hear him speaking?
Just a minute here, occurring in front of the son. As a result of that, I believe I suspended visitation and reappointed Mr. Lawrence to review this matter. Mr. Lawrence indicated he reached out to Mr. Gilbert. Mr. Gilbert was unwilling to pay Mr. Lawrence's fee. I put this over to try to address some of those issues. So maybe let me hear from Mr. Lawrence first if anything's happened since last time we were here, and then I'll let Mr. Gilbert address the court. Go ahead, Mr. Lawrence.
Your Honor, I have made contact with both Mr. Gilbert and Ms. Wilbanks. I have received payment from both of them, full payment. And I went down, I believe it was last Saturday, to Ms. Gilbert's residence and met with her and their son, Max, and was able to interview them. I spoke with Mr. Gilbert this last Monday over Zoom. And so I have had compliance in that they have met with me. They have provided Max access so I can interview him. And they've also both paid their bill in full. So we're good at this point.
Okay. All right. Thank you, Mr. Gilbert. Thank you for that cooperation. Mr. Gilbert, anything you'd like to say at this point?
I'm not going to get a fair thing here in front of Keith. I have stated my opinion before. His reports, I think, are incomplete. He contradicts himself. I think he's incompetent. And if the courts want this to go any farther, I would like a fair chance. I would like a different guardian ad litem involved in this, because our interview was maybe 10 minutes on the phone, and that was it. Over the years when we did this, I've invited him out to the house and stuff. He refuses. He's went to her house several times. He's refused to come out to my house. He does everything on Zoom, and it's such a short, fast, incomplete meeting with him that, looking out for the best interest of the kids, I would like another guardian ad litem if the court wants this to go any farther.
Right. Right. Thank you. Ms. Gilbert, any comment?
I mean, well, just Keith has not been to my house several times, but I mean, I think it's fine. I'm not sure that Keith is done with his, or what exactly he's doing. But anyways, no, I'm fine with Keith.
Mr. Lawrence, I guess I should give you an opportunity to respond to Mr. Gilbert's request that you be replaced.
Yeah, thank you, Your Honor. When I met with Mr. Gilbert on Monday, I wanted to discuss the issues that are at hand here. There's allegations of domestic violence and drug use by Mr. Gilbert, and that use was presented by Brenda, his current wife, in a post that Ms. Wilbanks picked up on and filed her paperwork to start this whole process. When I spoke with Mr. Gilbert, he was reluctant to discuss any domestic violence issues. He indicated that has all been resolved and that Brenda has dropped her protection order request. That may be true, Your Honor. However, the situation that led to it certainly could still exist. Also, he accused me of listening only to Aaron's side of things, and I tried to explain to him that was not what caused this whole process to begin. It was his wife's posting of the drug use and the domestic violence that caused this proceeding to get going. He then wanted to know, well, who was going to pay him for a week's vacation that he had to take time off of work to deal with this. And so at that point, I felt that no matter what we were going to be discussing, he wasn't willing to discuss it. He was being argumentative and trying to put all of the blame onto Aaron, who had nothing to do with starting this thing, other than being concerned about the post that John's wife put forward. So I felt it was non-productive. We would just be in an arguing situation. And so I terminated the interview at about 15 minutes.
Can I say something, Your Honor? Did
Yes,
Mr. Lawrence,
briefly.
did
Mr.
Mr.
Gilbert, go
Lawrence
ahead.
did Mr. Lawrence get the police report from the night that they're talking about?
I have a few police reports that were provided by Aaron, and I haven't had a chance to go through them yet.
So you got a report done and you haven't even looked at the police report. That's what I mean by incomplete and incompetent.
I don't think there's a report done yet. I don't think he's reached a final report.
No, Your Honor.
All right,
Well,
I'm going to replace Mr. Lawrence in this case. Do you have any recommendations at this point, Mr. Lawrence?
My recommendation, Your Honor, is to continue status quo at this point. The court wanted me to provide a full report on this before making any changes on the visitation. I would recommend that we continue with that line of reasoning and give me a chance to totally sort through this thing.
All right. Mr. Gilbert, what would you like to see happen?
If the court wants to continue this, that's fine. I'm willing to do what the court wants. All I ask is it to be fair. And Mr. Lawrence, knowing how I feel about him and how I felt about his last reports over the last 4 years, I'm not going to get a fair chance. So I think if the court is really looking out for the protection of Mac's 11-year-old boy in this, they would assign a different guardian ad litem to come out and actually do a complete report, because I'm not going to get one from Mr. Lawrence.
The allegations that
I'm willing to take UAs and clear this up. I mean, you want me to do weeklies, whatever, I will go down and do it.
okay. The allegations deal with domestic violence and potential drug abuse. So the court needs some objective information regarding that. Mr. Gilbert, what I'd like you to do is what's called a 12-panel hair follicle test. You can do that at Columbia Wellness, or there may be another place to do it.
Whose cost, Your Honor?
at your cost, sir. And also, I'd like you to have a substance abuse evaluation. And that, I believe that can also be done at Columbia Wellness. It'll probably take about 3 weeks to get both of those completed. So I'm going to continue the status quo for 3 weeks. That goes to the 22nd of February.
So, Your Honor, my kid is being suffered here. He don't get to spend time with me and stuff over this. I mean, I'm found guilty on something that I haven't even been to court or anything on, and my kid is suffering on this. And the police reports, if you get the police reports from when the sheriff was out here at the house and stuff, it clearly shows I did not have a problem. I took the breathalyzer, I did everything out here. And if Mr. Lawrence asked my kid if he seen the cops out here, my kid was nowhere even here. He was not here at the house at the time of the incident or anything else.
However, the declaration from Brenda that was filed with the court and was attested to under penalty of perjury indicates that domestic violence occurred in the presence of your son.
Oh, it was the sheriffs were here and stuff, and we have a parent plan in place, and we can look at the dates that the police reports were done on, and it will clearly show that the parent Max was not with me on those weekends. He was with his mom. The parent plan would clearly show the dates and everything else. That's all I'm asking is the court to look at that, look at the date the police reports were filed, Max with his mom, not even with me. So what was put in that report is incorrect.
Okay, so let me invite you to do your own declaration, attach the police reports, and make that argument because that information is not in the file at this point. Mr. Gilbert, let me tell you that if the hair follicle test is negative, as you're telling me it will be, if the substance abuse evaluation comes back okay, I want to spend time with your son, and we'll work towards that. But at this point, given the allegations, I need some objective evidence to make sure we can take that step.
You can't make up a week's paid vacation that I saved up all year long over Christmas and stuff. You can't make up these weekends I'm missing. I have to work. I'm behind on my payments right now on everything else. And I'm going through all this bull crap. And like I said, if Keith did his report correctly, he would have got the dates. He would have seen the police reports, and he could have verified that Max was not even with me. It should have all been cleared up over this. And that's why I'm asking for a different guardian ad litem to be assigned to this case. Because dates, clearly, there's a parent plan that is in place, and it would clearly show my kid was nowhere around.
Okay, sir, I want the objective test done before I make the next decision in this case. Okay.
Your Honor, if I might.
Yes, please.
On the substance abuse evaluation, I would suggest that the court allow input from Aaron Wilbanks. Usually when we have a substance abuse evaluation, and if there is an input from other parties, they can often not get a full picture of the issue.
Okay, I'll agree to that. And so wherever the evaluation is, Ms. Gilbert will need to be informed so that she can talk with them.
Okay.
Can we ask for this to go both ways, Your Honor?
Say that one more time.
Can I ask for this to go both ways? Both of us? Aaron Gilbert has not held a job in over a year and a half. She cannot stay working at one place, so I guarantee you she's not going to pass one. So I have to find it on Facebook or something? Do I have to get something posted out there? Ask her how many jobs she's had in the last year and a half and how many jobs she's lost in the last year.
Can I object to any of this? He literally is just rambling with zero He has not, like you said, Judge, presented any paperwork in any sort. He is just rambling.
I will prevent the paperwork.
All right, we're going to bring this to a conclusion. I've made my ruling. I need to see the hair follicle test and a substance abuse evaluation. There's no allegations against Ms. Gilbert at this time.
There will be.
Order that she do anything. And we'll be back here on the 22nd of February at 9:00.
Oh, thank you.
Thank you, Your Honor.
That would be Joshua Chavez and Irene Chavez.
I'm here, Your Honor.
All
I'm
right.
here.
All right. Dave, why don't I start with you? Have you, I believe I ordered the visitation plan that you set forth, except for the Wednesday visits last time we were here. And have you checked in with the parties and how they've been going from your perspective?
So that's correct, Your Honor. The visits, as far as I have been told, are going well, or they're happening. We're also supposed to be here for final documents, or for not final documents, but for presentation on the documents from your prior order. And I haven't seen those yet, so I don't know what the process is of getting those done, if Mr. Chavez has done that or not. It was his responsibility as the petitioner.
Your Honor, I'm not ready to finalize this.
No, they weren't final, Ms. Chavez. It was just from the prior hearing that would provide for the order that the judge gave at the last hearing.
I did do a bench order
Okay.
on that.
Yes, but I have a question on that one.
Go ahead.
Mr. Sergey actually lives at my residence. He's on my lease. So technically you are kicking him out of his apartment. And if you guys want documents of that, I will go to my landlord and get a document because he signed papers. So how is that?
That would be new information, Your Honor. Ms. Chavez, when I met with her and during my investigation, Mr. Sergey did not live with them and had his own residence in a different town up north, I believe Olympia. So that would be something new, and that would be in direct violation of the order.
He was coming every weekend. And they said because he comes every weekend, or he was coming every weekend, that he had to be on my lease.
All right. Well, Mr. Sergey cannot have any contact.
I would like to understand why, because if you guys looked in Mr. Chavez's past, in his juvenile, he did something, but I don't know the whole situation, what happened. And then he has the assault on his record. And then he has the open CPS case, which no one's doing anything about.
Your Honor, that had no relevance with this.
Just a minute, Mr. Chavez. My understanding is there's a felony conviction against Mr. Sergey as an adult.
That happened years ago.
And it's concerning enough that the recommendation is he not have any contact with the child.
But I have more concern of his dad. I mean, he's my oldest, and we're still trying to get it prosecuted. No one has talked to him, which is a joke.
So, Your Honor, I have been very thorough in my investigation regarding
Let me hear from Ms. Day here for a moment. Okay, go ahead.
I've been very thorough in my investigation of those allegations, including the law enforcement records, the records from DCYF, et cetera. There is no open case involving father. There is no open investigation regarding those allegations involving her daughter. That is a closed deal at this point until there's more information. Law enforcement is not pursuing that. They may in the future. I can't speak to what could happen in the future. But based on those concerns, my recommendation was that the overnights occur in the grandparents' home so that there would be no concern for this child's safety. I think that's more than appropriate and adequate to protect this child.
How is he not protected when my son was always with me, and when Mr. Sergey with me, he was never alone with my kids? I don't understand it. Especially when it happened 14 years ago, almost 15.
So we're just here for that moving forward, Your Honor. Do you want me to do more investigation? Is there something else you would like for me to do?
I just didn't think it's fair because both kids keep asking about the person and they were happy. I mean, he helped me take care of my kids because my just as not gave me a dime for my son. I don't want shit from him because I've done it all. I've worked my ass off to take care of my kids.
All right, we can leave the words somewhere else, okay?
I have proof. I could go get proof of showing I've always been working. I always have. I went back to work after my son was 3 months old. I've maybe been out of work a week or two, and then I would have a new job. I've always supported my kids. I don't need Mr. Chavez's money. I don't want it. But I think it's crap that I just don't think it's right that you're taking something that a man is willing to help and has not done anything. And it was 14 years ago. I wish you guys would give him a chance. And I know Mr. Chavez is mad that my son said I have two daddies. I think that's disrespectful that my son did it, but he's 6. He don't know better. And he's never said it in front of me. He's always called him by his first name. So I just wish you guys would give him a chance because it's been 14 years ago. Just like if Mr. Chavez did something like that, I'd be like, you know what? Why can't give a chance? Especially if that big gap.
All right, let me hear from Mr. Chavez. How have the visitations been going for you?
The visitations have actually been really awesome. I was actually able to take my son to the store so he could get his bananas and stuff. And, you know, we just did a lot of hanging out together. We bonded a whole lot. You know, but can I say something, Your Honor? If that David guy is going to be living at my wife's residence, I really want to have full custody of my son because of his safety. Not to mention when my dad was dropping off Austin, Kyrene would be out in the parking lot talking with my dad and Austin be upstairs with that guy.
All right.
And
I'm not going to change custody at this point. I'm going to leave the current order in place, except I'm going to add in every Wednesday visit as recommended by the guardian ad litem from after school until 6 p.m.
That's a 3-hour. There's no point of that. That is no. He gets him every other weekend. I'm not gonna let him have him on Wednesdays. We're not gonna screw up his ordeal. I already have to turn something in to Child Protective Services that I've known my son has done. And I don't think it's dad, because I don't see dad doing that, but it's just to protect him. But we need to stop changing it on the boy, because the boy is acting out. And this is not fair to him.
Ma'am, I
not understand there's a 6-year-old that is affected by this, and I'm willing to see him every other weekend, but I'm not willing for Wednesdays because you're gonna break his schedule. You keep breaking it, and you guys don't understand. He's gonna act out again.
I'm providing visitation to a father who has a constitutional right to spend time with his son.
Yeah, but okay, so
And
you can act out.
that is now going to include Wednesday from after school until 6.
Thank you, Your Honor.
I'm going to set this for another hearing for March 1 at 9 o'clock. If either party wants to inform the court about how the visitations are going, or if Ms. Chavez wants to present an argument as to why Mr. Sergey should be allowed to have contact with the child, I would like you to submit that by way of a declaration that's filed with the court and also provided to Ms. Day so that we can consider that at the next hearing.
Okay, how can I object on the Wednesdays?
Object to what? To the Wednesday?
Yeah, I mean, do I have to get paperwork that saying from the psychologist at school and the school teacher that every time they say something, it affects them in class?
The psychologist at school will say that Wednesday visits are a problem, then I'll consider that.
Okay,
Does
but
that-
Your Honor, would you like me to follow up with the parties and see how the visits are going before March's hearing?
Yes, I would like you to do that. If you need
Right.
me to authorize more time, I will.
All right, thank you, Your Honor.
okay, but he's not allowed to pick them up. Grandpa pick them up from, right?
Mr. Chavez will pick up from school.
He
Yes.
can't get too close to my daughter. My house is right behind the school.
More than 500
Well,
feet away
then-
from the school.
Yeah, that's
It doesn't violate the order, Your Honor, from.
Grandfather can pick him up then, Mr. Lager.
Yeah, because you told me last time that you were gonna let the grandfather. Is that starting today or starting next week?
Start it next week, okay?
Okay, because that's just
Thank you, Your Honor.
Okay. All right, thank you.
Honor, how long is the visit on Wednesday?
It's from after school until 6 p.m.
Okay. Thank you, Your Honor.
We're here to address a child support request by Ms. Jackson. Let me, I guess, tell you what I've gathered from the declarations that have been filed. Mr. Cahill filed a declaration saying in 2019, there was an order entered that because the children were being shared in terms of their residence between the two parties, the court ordered no child support be paid by either party. And that's been the case up until, now. He doesn't feel there's been a substantial change in circumstance that would support awarding child support at this point. Ms. Jackson is coming in saying that she didn't agree to that order back then, that she does feel there's been a substantial change in circumstance in terms of additional income to each party and the fact that the children that were living with the parties have switched, and also the adult children no longer are being supported. So that's what I hear. There's also, I think, some dispute about how much money Mr. Cahill makes. I guess, let me tell you my thought, and then I'll let the different parties address that. It's been since 2019. I think there is a substantial change in circumstance. I think just based on the change in income, there is a need to relook at the child support issue. At this point, Mr. Cahill makes substantially more than Ms. Jackson. And so I think there would need to be a transfer payment from him. I can tell you where I think that should be set, but I guess I'll give the parties a chance to, and particularly Ms. Gilmore, to argue the issue of substantial change and whether there should be child support at all.
Yes, Your Honor. I just have massive procedural concerns in this case. I understand that we have a pro se litigant, but they're held to the same standard. So as said before, the court on any case, Washington State is a notice pleading state. Within her motion, she has an obligation to support her case with facts. We literally, in her declaration for her underlying request for child support, she doesn't even address it. She doesn't even make an allegation of what she's even requesting for. She doesn't present any financial information. She doesn't present any sort of worksheets or request for any sort of transfer payment whatsoever. And then in the 11th hour, literally yesterday, we have new information contained within a reply declaration that goes way outside of the scope of the underlying motion here. So as we stand before the court, my client doesn't have an ability to defend himself without even presenting worksheets. We're before the court without even worksheets. So I don't know how to proceed here. And this is the third hearing on this issue. Again, she has an obligation to present a motion with a declaration asking for a request in addition to worksheets. And my client it's basically a moving target at this point. So I frankly am frustrated by the sense that we still need to procedurally go before the court with a motion timely served with the declaration, and my client should have the ability to adequately represent himself through due process. So I ask the court deny it at this point, or at the very least reserve, and then this needs to be addressed either on a final hearing or an additional motion with proper service and a declaration.
All right, Ms. Counts, do you want to address any issues?
I actually do believe that I did file when I filed my original pleadings, I did put in some child support paperwork. I did not have access to Mr. Cahill's income at that time.
Did you provide that to Ms. Gilmore? I know I have sheets.
Yeah, it was directly served to Mr. Cahill, yes, sir. It was before Ms. Gilmore was representing him, sir.
Okay.
Can you reference where, if there is a declaration mentioning incomes or worksheets, can you reference when they were filed?
The original filing back in October when I originally brought motion before the court.
Just give me one second, I'm trying to pull that up. Based on the information I had, the motion itself was just addressing the transfer of custody of Elizabeth. It made no reference whatsoever beyond just the general request within the motion, underlying motion, that she was requesting for a child support order to be entered. That motion didn't even reference the fact that there was a temporary order at that point.
I don't know that it referenced the temporary order. I think I learned that from your declaration. As I've looked at this, let me tell you what conclusions I made. I'm going to tell you where I'd like to go, and then we'll put this over 1 or 2 weeks to allow both parties to come back and say, no, you shouldn't do that. I think the issue of child support is before me. What I have from Mr. Cahill is a document that shows that he made $90,000 last year. That was till November. I'm going to accept his representation that he did not take a payment in December. Ms. Jackson is represented that she makes $3,700 gross. I went to support calc. That shows that if it were Ms. Jackson making the child support payment, it would be $712.04. If it was Mr. Cahill making the payment, it'd be $1,339.96. But it seems to me, since they each have one child, that those numbers should cancel each other out or be a credit, which leaves a transfer payment from Mr. Cahill to Ms. Jackson of $627.92.
So I can tell, sorry.
And the way I look at that is that is a way to, through this calculation, to ensure that both children have an equal amount of support. The law says that Ms. Jackson should be contributing $712 and Mr. Cahill a bit more. It just seems that that's a way to equal things out for the children.
And respectfully, Your Honor, I don't think that that's necessarily the correct analysis pursuant to statute. I can tell the court that I did run a worksheet for myself, and with the residential split adjustment, that comes out with a transfer payment from my client to mother in the amount of $352.45.
Okay.
And that's setting my client at the 90,000. That's setting her based on her her wages we received based on the pay stub.
Okay. So I appreciate that, and what I'd like to do again is put this over a week or two so that you can provide that analysis to me. Ms. Jackson can provide whatever argument she wants to me, and I'll make a determination which way I should go in terms of the amount. But I think today what I'm letting everybody know is I think child support is before me. I think there needs to be a transfer payment from Mr. Cahill to Ms. Jackson because he makes more. I am accepting that his last year's gross amount is $90,000, which accepts he didn't get paid in December. So all of those things I'm accepting today. What I'm not making a decision on is exactly what that transfer payment is going to be. Okay.
And I can get those filed today or tomorrow.
Well, if we put it on next week, that's February 8th. Why don't we do that? Because we basically have most everything in front of me right now. So I'd like to see that, and I'll make a decision on the amount.
And I can present likely a child support order at that point, just knowing the court's ruling, so we can avoid an additional presentation hearing.
That's fine. If you want to submit that too.
Okay, thank you.
Your Honor. Hi, my name's Crystal Long, and I am at work on my break. I'm just, they told me to see if we could call my case possibly, because my break's over almost.
And what is the full name of your case?
It should be Long versus Roughton.
Oh, it's in the Roshan case.
I don't believe that's the same case as the Roshan that I'm on.
Okay.
That case should be literally 5 minutes if we can hear that. I'm supposed to be in Clark right now.
Yeah, you're fine. After that, if that's possible for mine, yeah, go ahead.
Okay. Thank you.
I don't know that I have you. Is she on the 10:30 docket?
They told me 9 a.m.
What is the name of Roshan?
Taylor.
Roshan?
Yeah, Roughton, Rowton. I thought it was the second.
It's on for tomorrow at 9 o'clock.
Tomorrow, 9 a.m. Okay. I have work tomorrow. So how would I just raise my hand again when it starts so I could go possibly first?
I am handling that tomorrow, so I'll try to call you.
Okay. Thank you. Tomorrow at 9 a.m. Thank you so much.
Thank you.
Bye.
Yes, Your Honor, and it's Roshan.
Roshan, thank you.
There were a few items that I don't understand why Amanda changed her mind on. My storage tank, the flatbed that we had, it's massive, Your Honor. It's 8 by 8 by 8 cubed, 2,500 gallons. Somebody filled it with water, so I had to pull the drain plug and drain it, and we ran out of time to load it onto one of our pickups. And now I'm being told that I can't have it back. It's $2,000. I missed my longer extension ladder to reach 2-story roofs when I inspect homes. And then also, I was denied any of my birds any of them.
Any of your what?
My birds, my chickens.
Oh, your chickens. Okay.
Yep. That one specific little rooster. Yeah, that's a pet. She's already keeping both of the cats that I bought. If I could get some sort of a judgment from you off of those items, I'd say that's it, really.
Are you able to go about your job as a home inspector at this point?
Yeah, there are going to be a few that come up. I inspect primarily down in Vancouver, and there's different airfields down there. And when it comes to getting clearance for drone usage, sometimes it doesn't quite work, but for the most part, I'll be all right. It's just nice to have that 24-foot ladder when I need it.
Ms. Gilmore, do you want to respond?
Yes, I was trying to look back through my emails. My assistant has been handling the property transfer issue, and so I don't understand. I can't find the exact reason that my client disagrees to those transfers, but I know that there's a basis. The previous court's ruling was that if it was disagreed, that it needed to remain with my client. And I think that we can deal with values and transfers of property on a final basis, and any sort of judgments will either need to be agreed by the parties or determined by the trial court. So I just asked that there be no further rulings regarding the transfer of property. I think the vast majority of the property was transferred. There was, I would say, hundreds, if not thousands of items transferred between the parties. So I asked the court make no further rulings regarding this.
The only thing that I'm concerned about is the extension ladder, which seems to be related to Mr. Roshan's work. I wonder if we could get that to him. And I think at this point, since there seems to be a dispute, the other issues, including the birds and the storage tank, are going to have to be addressed at the trial court level. But I guess, again, I think that the extension ladder is going to be a fairly hefty expense if Mr. Roshan has to replace it. And I think that should be provided. Ms. Gilmore, do you think you can facilitate that?
So I just messaged my assistant, and she indicated that it wasn't the ladder itself that was the issue. It was that she doesn't want him to continue to be on the property because he allegedly was threatening her cousin. So that was the main issue. But if we can work to facilitate a transfer through a third party, then I think that would likely be fine. I understand the court's ruling. So I will try to facilitate that accordingly.
I don't want Mr. Roshan to go back on the property to get it. It needs to be provided to him somehow.
Okay, I'll get that done.
Could I say something, Your Honor?
Yes, please.
Yeah, I can have up to 4 witness statements that will verify that there was zero communication whatsoever at all capacity between myself, Megan, that's the niece, and I believe Bill Jenkins was also up there. They spent 90% of the time inside the house. And as far as the ladder goes, I think the best way to transfer this would be for Amanda to take that ladder and then drop it off at her mom's. My youngest daughter has started going over to the mother's house for visits. There's a young child in that house that she plays with, Amanda's sister's daughter. It's been going great. But if that ladder could just be dropped off there, that's a really simple solution to this.
Are you able to get in touch with Mr. Roshan, Ms. Gilmore, to
yeah, we'll get this done. I understand the court's ruling.
Okay. What needs to be done now in the future, other than, I guess, set this in front of the court for a resolution.
We need a transfer of some income information, retirement information, bank information, debt information. I was hoping to avoid a formal discovery exchange, but at this point, given the appraisal, I likely will need to at least do a pretty basic request. And then once I have that information, we can set it for a settlement conference.
Okay. Do you want me to set a review hearing to make sure that that information's been exchanged?
I don't think it's necessary, just to avoid additional costs of the parties and taking time off work.
Okay. So, Mr. Roshan, in order to move this forward, Ms. Gilmore is going to send you a request for various financial documents, which she will need, and both of you will need to go forward with this case. If you would like some financial documents from Ms. Roshan, you can send that request to Ms. Gilmore. Okay. So that's going to go on. When those documents are exchanged, then it's required that the parties set this for what's called a mandatory settlement conference to see if there can be a resolution to all of the issues. If there cannot, then it will go on and go to a trial. So that's going to be the next steps at this point. And I don't know that I'm going to set any more review hearings. I think all of that can occur outside of my involvement, unless for some reason either party feels that I need to come in and make a decision in the future. Okay.
Great, thank you.
Okay, thank you.
Thank you, Your Honor.
Your Honor, my name is Laura Hinton, and I was just wondering if I could go next, as I'm a mail carrier and my boss is needing me to go in as soon as possible to get mail out to people.
Okay, we can do that. So that would be Lara Hinton and Jason Hinton.
That's correct. I'm here, Your Honor.
Ms. Hinton has submitted to the court final dissolution documents, which is called findings and conclusions, and then the final divorce order. So first of all, Mr. Hinton, have you had a chance to review those?
Yeah, I got them a couple days ago and I looked over them, and if I can go on and share something else with you, I would appreciate the ability to do so.
Okay, go ahead.
So first of all, I apologize because I feel like I've honestly wasted a lot of time with the court and stuff. I was in an accident, like I said, a motorcycle accident the day after I was served with the papers, and among having a broken hip and ongoing infection with my leg and almost losing my leg, I actually lost a bunch of memory and I wasn't able to function properly. And so unfortunately, I didn't respond accordingly throughout this whole process. And when I finally managed to get it, was able to get the things together and able to respond in time, I feel like I was just a little too late. So I don't know where I go from here. I called the court yesterday. They said I had filed what I needed, but I don't know still if I am or have.
Well, where we're at on that is there was an order of default entered, and then about a month later is when you responded. What typically you would need to do is file a declaration explaining why you didn't respond in time and asking the court to set aside the default.
So I did actually file that paperwork that you're speaking of, the declaration of why that happened. And I think it was a request to reverse the default order or whatever. Yeah. I apologize. It was really quite a lot for me to deal with throughout this whole process, and I apologize again. Yeah, I called the court and they said that I had the declaration filed, and well, she said I had everything I needed filed for this time, but I just don't feel like I do. So
So you
You know
filed
what?
a declaration on December 19th.
So, oh, you know what? Maybe I have it here still. I might not have even, it might not have got a copy filed for the motion to vacate the default judgment.
So, and I'm sorry to be a little legally technical with you here, but I think this needs to be done in the correct way, and the court has
Okay.
to approach it in the correct way. Because I can't tell you whether, well, I'll tell you what I will do in a moment.
Okay.
I don't know whether I'll set aside the default or not. I need to see a motion. So what you would need to file is something called a motion to set aside the default. And then a declaration, your declaration on December 19th hits on some of the things, but you need to explain why the accident prevented you from responding in time.
Okay.
Okay.
All right.
And, you know, if you were in the hospital, if you were on medication, if you weren't able to concentrate, those are the kind of facts that the court would need to consider.
All right.
What I think maybe we need to do,
Your Honor.
Ms. Hinton, I'm going to give you a chance to respond, but I'm going to tell you what my thoughts are at this point. What I'm thinking of doing is putting this over to February 15th, which is in 2 weeks. So Mr. Hinton can file that motion, and on that date, I can make a determination whether I'll set the default aside or not.
Thank you, Your Honor.
And if I set it aside, we'll need to figure out what your objections are to Ms. Hinton's proposed orders. If I don't set it aside, then I'm probably going to sign her orders as she's presented them. I'm not making a decision one way or the other. I just need that brought before the court in the correct manner.
Well, I do appreciate your guidance on this, and thank you very much for.
Let me ask Ms. Hinton if she has a response to that. Go ahead.
Yeah, and his accident, there was no police report. He was going to make a drug delivery and ran into the person in front of him because he was high. I have been told that he walks just fine. He did, I hear, have an infection on his leg, but he has MRSA from his drug use, not from the accident. I was really hoping that you would sign the papers because I want to be done with him out of my life. As you know, we saw you on Monday with his girlfriend, Linda Perez. They continue to stalk me and harass me, and I just want this done and over with. His paperwork that he sent me in it is just stories and lies. And it's difficult for me to take time off of work. As I told you, I'm a mail carrier and people are going to be late today. But if that's what we have to do, then put it off. Then I guess that's what we have to do. But I was just praying that you would just sign the paper. And he took $75,000 worth of tools. He came with more than, or he left with more than what he came with. He came from prison in 2019. We had a very short marriage. He has everything that he needs to live his life. And I just want this signed and done and over with so I can move on as well.
Okay. Understand that. I am going to give Mr. Hinton an opportunity to set aside the default to this. If you have a response that part of what you were just telling me, I invite you to file your own declaration in opposition to that motion, and I'll consider both. Okay. So I think at this point, I need to put this over to the 15th to give everybody a chance to get that paperwork before the court. And then we'll make a decision on that date.
Okay.
Thank you very much, Your Honor.